Hello, welcome to the SAPI IP Business Talks. Today we are in Munich and my guest is Roland Pültz. We will talk about the relationship between software patents and software as a medical device. Now, very fascinating, complex topic, and I'm so happy that Roland is with me because he's an absolute expert on that topic, and I'm happy to learn something about that. Roland, my first question to my guests is typically, how did you became what you are now? So explain us a little bit. What is your background? What did you study, and what brought you to this strange field of intellectual property? And in your case, this again very special thing of software patents. I'm very curious to listen to you to understand that.
Thanks for the introduction. Yes, so I studied physics, and the reason for studying physics was, in the end, that I was interested in a lot of technical different fields. And normally you have to specify into one if you go for mechanical engineering or something like that. And I wanted to have a broader view on that. And after having finished the studying, I realized that you might not be suitable for specific jobs because the specific persons having specifically studied that are probably better suited. And then I looked for jobs where I can have a variety of technical inventions, developments, different areas where you could use this huge knowledge, this broad knowledge also. And what is not more perfect than the patent field for that, because you have every time you have something new on the table, every time you open a new patent application, it's something different. And that's very interesting. It doesn't get you bored. You have a bouquet of flowers, you could say, a lot of different ones. And that's what motivates you, what was the reason I, at least, went or wanted to be a patent attorney.
And as a physicist, I mean, we have the same university training on that, so I have a certain understanding what physicians know and what they don't know. So as a physicist, why you went into this field of software patents? What do you think is specific fascinating there?
I went for the software part because I think the software part is that one that is the most important one, because we have the digitalization, the industry goes more and more digital, also in the private sector. And to be on this very end of inventions, on the hot topic ones, that makes just the most fun. And it's also the thing that I believe contributes a lot to humanity developing furthermore. And I think it's very important also to be aware of what is going on there. Also, when you look at AI and that kind of stuff, what is going around, to know what's coming next, to know how it helps, to know how it makes things better. This is why I am so interested in this field. And in combination with that, of course, comes, as I said before, the human itself, which is the medical area. And I believe there's a lot of things that can be gained from both sides that can be combined very well and to the best for us.
Yeah, I got you. I mean, at the end, everything becomes software, right? So we had so many gadgets, so many tools, devices. At the end, today they are an app, and when you invent something, most likely it has something to do with software. That's a fascinating development over the last, I would say, 10, 15 years. And it's also fascinating that in former times, only the software industry was interested in software, right? And today, as you said, the medical industry, medical device industry, so every industry has to deal with software aspects, with software components, is affected of software, and that leads also to a certain demand of support. Because when you have a traditional legacy in, let's say, electronics or physical devices, and now you have the software layer. I mean, that what is your experience here? I mean, that is a big challenge for the companies, right?
It's a lot of challenge, specifically if you're not started in the software application. I would say most companies come from the other side. That's the more engineering part, which was just physical devices and how to make better engines and that kind of stuff. And now they deal with the complications of how to improve the physical reality by software. And as you correctly mentioned, this is in all technical areas. And I believe that for someone coming from that background, it's also hard to understand what is actually software doing. How does it look like? How does it work? Not just the interface that I get presented, but what are behind the software, the ideas and also the inventions that brought me there. It's very fascinating, but also very tricky because you need to adapt a certain way of looking at software, which is not just the typical image you have of the engine that you see, okay, this is this part, this is true.
Yeah, I got you. I mean, we have this very strange discussion: can software be patented? To a certain extent, I don't know who said that. I mean, Sebastian Goebel or so, some of them said on LinkedIn, this is like asking, can you patent electricity? Yeah, so it's not helpful to ask that kind of question. So and then the other says, yeah, it has to be technical. Like, yeah, I mean, that's a triviality because otherwise you cannot patent it. That's the prerequisite. So obviously there are two fields which have which developed on their own sake, and now we want to bring them together, and that means it's not like that, it's like that. So we have to check when can we do something with patents and when it's not a good idea, or as you said, what is my perspective on what is invented? What do I want to call the invention in a certain case? Maybe that is something. I mean, this was always true in all kind of inventions, but for software, because of the complexity and the relatively high degree of freedom, that is especially true. So when you interact with inventors, with companies, how do you use these degrees of freedom to ask or to define what is invented here in this case? What do we call the inventions? How do you use that?
That's a very good point, actually. That would have been the very first thing I always do with my clients, to say, okay, did you train your inventors to identify the inventions? Because it's not as similar with the physical device that you can look at and touch and see, okay, this was a new property, this is newly designed compared to the previous one. It comes down to specific questions relating, it's parallel to the physical world, where you could just simply say, what does it make better? In simple words, putting there like, what kind of work did you do? Why didn't you copy it from the other one? What was the problem? And then he answers, yeah, okay, had there a security issue, for example. And then okay, this is something, you made it more secure. So it's on this basic level where it can start with the inventors and give them a first idea what can be taken to the patent world or what may not be taken to the patent world. But as you also mentioned before, it's even our patent world, it's very hard to distinguish between, there's a gray zone to say, okay, this is definitely going to be patented and this is not going to be patented, because we have a shifting also in the jurisdictions and the decisions that are made. And therefore, I would always say to my clients, at least, that get your inventors at least to that point that they give you inventions which may be used, and then in discussion with us, who can specifically look into it and have a different view on it, of course, we can discuss whether this has a good chance in the patent world or maybe not. And then, of course, if you say, okay, we are not going for a patent application, there are also further ways. So this always comes also with the software part, that people like think, okay, if I can't get a patent, everything it's finished. We don't have any benefits. We cannot use it. We will just have to be always the best, which is of course not possible, as we all know. But some people believe that it's fine for them. But you have also further options, like you keep it as a secret, because the nice thing is with software is that it may be distributed. It may not just be on your computer, something installed locally, but it may be in the cloud, for example. And then if you as a client just have an input, it will be processed in the cloud, and you receive some output, and you're just interested in the output, but you don't see how it is processed. For example, then you may keep it for yourself and have thereby your advantage. But this is more in the discussion with the client where you analyze, should we go for a patent? Is it possible? And if so, how we do this? This is another part, of course. But the other part is that even if you don't go for it, how can we handle it to benefit the most of it?
Yeah, absolutely. And I think sometimes inventors in general, they treat patents like an invention award, so that they want to be recognized as inventors, and so they want to have a patent. So that's one direction, right? And so the patent is the ultimate goal. And I would say, yeah, first of all, it is just a cost burden, and we should think about that, whether it makes sense or not in a concrete case. So despite of the fact that we get the patent so we can patent it, we should also ask the question, should we patent it, or are there even better solutions for the issue? But what you said is, I mean, I try to explain that always, that I say, what we call at the end of the day invention, in terms of what is patented, is a creation, a co-creation between the IP expert, typically the patent attorney, and the inventor or the inventors. And it is not so that in a typical case, the inventor comes with something which is finished. It is the invention, and the patent attorney has just the job to wrap around the patent. It's not like that, like a mechanical solution which you put on the desk and say, okay, describe it. It's the invention. So the more digital the things become, the more fluid they are. And at the end of the day, we have to ask the question, how can we describe it that the patent office is satisfied, that they say, okay, we accept that, it's technical. But on the other hand, that we have an exclusivity, which is really something worth in the hands of the company. So think about infringement, enforceability, all that kind of questions, that it is associated to meaningful use case. So which means it is a co-creation. So even when, from a legal standpoint, there is a clear separation between the attorney and the client, of course, but de facto it isn't so. And when then in addition comes the state of the art in between, then we have a third influencing factor, which we have to take into account. What we see at the end is this collaborative created patent, which has a certain scope of protection or exclusivity, and this has to be made with creativity, with inspiration, with knowledge from both, or at least from all parties which work here together. This is what I hear when I'm listening to you.
I totally agree with you. I stress this point a bit more, because I think in general people underestimate that when it comes to this fluid part of software, that it's not an easy decision. And as you also said correctly, it's probably also the attorney work to draft it into a certain way. On the other hand, of course, the attorney can only draft what he was given and he did understand, but also made aware of that there is an invention. And only by this combination of both workforces and discussions and exchanges, I think then there's a very healthy, nice IP coming out of this. While if you just treat it as, okay, here's the invention, just wrap it around, as you said, of course it comes something out, but there may be some stones in the future that might be a hurdle for you. And it's a money burner in the end if it doesn't work.
So we talked about software, the invention process, the question of the role of the different players, and that this is especially for digital solutions, for software-based solutions, it is specific. It's a special situation. And so these co-creation, so to speak, situation. Let's talk a little bit about software as a medical device. So can you explain for the audience a little bit what does that means?
It's a good question. It's generally speaking, it's just software's applications which are used without the medical device, just being a program. So it's not the operating device itself that you use during surgeon operation. It's just the software. And just to give you some examples, like this is image analyzing, processing. This is the data processing, the diagnostic part from the image where I say, okay, is this something that we need to cut out or not, that we need to treat? Or implant design is also a huge area. You say, okay, we have the image of the skeleton and the bones and that kind of stuff, but we need a very well appropriately designed implant for that. And this is just on the computer. It's just as software, and that's what you name as software as a medical device.
Yeah, okay. And another case would be remote monitoring of patients, something like that. Yeah, you collect data basically. Okay, got you.
Exactly.
So you want to improve decision making in the process and during diagnosis, therapies. Okay, got you. So we talk about software, obviously, in that case, and so. What is there something special when we want to protect a product with software patents, and this product is a software as a medical device? Is there something which we have to take into account? What is your experience?
There's a lot to take into account. I mean, we had that before. That is the technical aspect, which we won't go into detail now. But this has to be identified, of course, and discussed with the patent attorney. And then what we always experience is that this software, it's the whole software that's provided to the client. So we have one application. And what always happens is that in this application, several problems have been solved. And therefore, the very first step for us is digging into the invention and having a look at what kind of software parts do I have. So, because as you said, the software is fluid, and if I protect a whole step-by-step software, an analyzing part, for example, I protected this complete arrangement of steps. However, if someone else just takes 1 or 2 steps out of this is something completely different and won't be protected. And this is why we approach it more in a modular-based way, that we say, okay, this is the whole software, but probably it may be divided in several steps or different applications, modules that you might get a patent for or not. And based on that, you can create a much more powerful IP portfolio. And this is in a very fast-forward way how we would approach it and how to deal with the client here.
Yeah, and I guess that you have to explain that really to the clients, because first of all, it means, so I would say the typical expectation is the more we can cover our product, the better. So and then please put it all in this one patent, and then we have a one-to-one. This is the product, this is the patent, and that is the great thing which we would like to have. And you come with the complete opposite, and explain them that that this is not a good situation having all that aspects in it. That's the first thing. So from a pure legal point of view, it doesn't make it better; it makes it weaker. And in addition, that the countermeasure is to understand really what is really important and which aspects can be separated to have more powerful patents which are enforceable, and or even, I mean, another tricky issue is which can be infringed. I mean, that is also a huge discussion. Yeah, when you have these client server issues, and so that from an infringement perspective, the question, who do we really forbid something? I mean, that is something. So it's not just when you have this, wrapping a patent around an invention. Yeah, when you have this perspective, you forget that it is a forbidding right. And the cornerstone of a forbidding right is, who do I forbid what? So what is the infringement situation? And I guess that this is, it is difficult and exhausting to explain that to the clients. What is your experience there?
I totally agree with you. So there comes inventors, of course, that are very, very proud of their invention, or the company, sometimes also smaller companies, which just have this one software. But in the end, as you said before, you need to make an overview what actually happens. When is a patent something worth or not? And I think in the end, to make it out of this legal world in the business world, as you say, the patent makes then sense when you have a benefit compared to your competitors if you can forbid those. And it's not the client, probably the person in the end, the doctor, but it's the other competitors, the company who is a similar field as software providers. And if you come across these, they're very, I would say, more easily to catch, because these are the terms and words they understand. And then it opens the field up to say, okay, what part of the software actually is provided from the competitors that you should protect individually. And I mean, it does not exclude that you can protect the whole overall software. This is not excluded. It may be on top of that. But by having a very specific look at the landscape of the competitor landscape, I think from this kind of view, you get the clients better, and then you can explain why you draft the patent application just for this module or just in this combination. Because as you always know, coming from the legal side, with the legal knowledge, with the legal wording, this is mere words for them, but there needs to be the translation into the business language. And I think this is what our clients at least benefit from. It's translated into their world, and then therefore also can be followed up and then also understood and instructed to us back.
So what I hear is that your work has a lot to do with consultancy. So you coach to a certain extent your clients to come to a good decision on what to patent and how to patent it. It's not just whether I make a PCT or EP or whatever. So here it is really the question: what is a wisely usage of the IP system, here the patent system, or when you include trade secrets and others, so it's the IP system. And so what is a meaningful, a good business integration of this IP in the business model, in the strategy of the company, in the use case development, whatever. So this is much more than just, so the typical understanding of the work of a patent attorney is that you receive a more or less finished invention disclosure, and then it is more or less given what you write in the patent. Yeah, so like an IO transducer. So here, what I learn is that you really try to understand what the business challenges are with that software for that software company, and then how they can use IP to meet their business objectives.
Correctly. I mean, in the end, it's a very cost-sensitive subject also. A whole patent family costs quite a lot, 100,000 euros. So I always say, from the business model view, it must make sense, and it must also let the business stay healthy. That means that, of course, the money spent on IP should be worth it, but only to this degree where you need it, and the rest of the money is probably otherwise good spent in whatever it is, marketing, development, And by this, you have not only from me a long-lasting relationship because the client exists long, but on the other hand, he's also very happy with his business in the end. So this is something you need to take into account. It's just not just like getting the instructions, just drafting. This is not enough. And I also see it as a duty from the patent attorney to give options and translate to each option whether there's a pros and cons, why you should do it and why you should not do it. And this is what you should offer. In the end, of course, drafting and the offer section, the litigation, all that comes across, this is what they buy you for. But they need to understand why you exist for them. And specifically in this scenario here with the software, since also licenses may be taken to cover some parts of the software, it's a bit more complicated, I would say, or at least to realize for the client that this is a bit different compared to the physical world.
Yeah, and what I really like is that at the end of the day, the company has to make a business decision and not a legal decision. So it's a business decision, and law is an instrument which can be used in different ways for the business. And sometimes I have just a side note, but sometimes in the US, the business people, they managers, they are used to use law as an instrument to make business. So that's completely normal for them. That a lawyer is in a business meeting, and here in Europe, and to a certain extent, especially in Germany, business people have the tendency to say law is a different area. This is so when things are I don't know, broken or run sour or whatever, so then the law comes into play. But for normal business, I want to avoid anyhow to ask legal questions. And when it comes to patents, we have exactly that. You use law to achieve business objectives. And sometimes in these discussions, I have the feeling that some managers have really difficulties with this kind of, let's say, business integrations of legal aspects of, and this is exactly what you as an interface here has to provide. You need to have a technical understanding. You have the legal expertise, but you need also a deep dive into this business decision, because for the managers it's extremely hard to understand the consequences of this decision from a legal standpoint.
Exactly, and it's only possible if you have this exchange to have a healthy portfolio. And as I said, also with IP, if you think about it, you file a patent application which will be granted in the future. So it must be, just from this objective view, it's a strategical tool. And why not use this to cover up the other business parts? It's strengthening that. It's one pillar of the successful business model. And I think it's always very specific when you have to identify that. This is why I could not, to be honest, provide you with a general approach how to do this. You really have to go into the discussion and then go through this. Also for these managers and also for the technical managers, they know the technical aspects, that still they miss the legal part or just a very broad understanding of that. And this is where you come in. And if the client lets you do this, I think on the long run, it's very beneficial for them.
Yeah, that's this problem which I have always with our case study. So we published today our latest case study with Laerdal Medical from Norway, and we received a forward from Catherine Mills. She's the president head of the Norwegian Industrial Property Office. So brilliant, yeah. And Maria Boykova-Winans wrote it, and it's a great piece of knowledge about IP management in a medical device company. But it is not a blueprint. Yeah, so as you said, it is not a general recommendation. Do it like Ladera. So you can learn a lot from them, but we have in IP, we have to be so careful. So just because IBM was able to generate 1.5 billion licensing revenues in the 90s, that doesn't mean anything for you. It is just for your company. This was so, and there are good reasons why it was so. And Marshall Phelps is famous for realize that. But when he went then later on to Microsoft, he made a 180-degree shift to a completely different IP strategy, because Bill Gates needed that. Yeah, Microsoft in that time needed something completely different. Both are brilliant IP strategies. Both were extremely valuable for the companies, but they are more or less the opposite. So this is exactly when you say we cannot walk around with blueprints and generic recommendations how to do things. That is extremely dangerous. We can learn something from the single case, but it is a single case at the end of the day. So I would like to ask you something which drives me around, because these software as a medical device, this area is obviously highly regulated. That simply because there are critical decisions behind that, and so the regulatory institutions, organizations, they need often lots of information. You have to disclosure information to these authorities that they can that they can trust the software, and that they at the end accept it as a medical device. So as a part, so they that the software fulfills the regulative provisions. So how can you on the one hand obtain patent protection when on the other hand you have this disclosure obligation? So how could you deal with that?
That's the unfair point with the medical devices, that you need to take account for this risk. Obviously, the biggest risk is that there's something publicly available from your invention. So this is the latest red flag that you should realize. But before that, with these regulatories, they are very well defined at what stage you have to provide what kind of information. And you should always have a close look at, is this information I need to provide there really the inventive part of my invention? Or is it just, okay, this is the use it like this, you make some inputs, there happens something, it is processed, and then it gets out like this, helps him to decide on what kind of therapy he does, broadly speaking. But you still have excluded how is this therapy determined in the end, which may be the inventive step here. And there are some certain degrees of freedom on the way with these regulatories where you can say, okay, I don't need to provide all details thereof, but I can just go broadly through this. Another thing here is that at least some jurisdictions or some authorities offer that the information that you provide may not be published, or a certain way, like be it with an NDA or something, that it is not disclosed. So therefore, when you look at this road that you go with the authority and you see, okay, where are the red lines, then you automatically have the answer to how do I go with my patent application? Because of course the patent application should be filed before something relevant to it is published. And on the other hand, the good thing is that you have probably more than one invention, as we mentioned before, and probably some of these parts are already well developed, which may be prioritized and therefore filed before you have the red flags there. And probably there also later on, you can have some further development, which was not yet known when you firstly applied, and later on you have it. So you also did not provide it to the authority, right? So it also gives you don't have to determine on all of it. That's what some clients always think if they have their software, which is most of the time not done yet. that they have to decide on anything, but you can have some kind of table where the sum tells you a priority of what should be used for patent applications until a certain time, parallel to this regulatory authority, and which may be dealt later.
Okay, so so what I learned is the question of the interrelation between patents and the regulatory affairs. So this is a process over the time, which has to be managed, and you should have a certain strategy. Which information, which content I take for what, and you have to organize that. You need a strategy. You need an operative implementation, and this is a process in time which you really have to understand, because otherwise you ruin maybe both, but definitely you can be in danger that you won't get a patent because of an public disclosure. And so that and you do that, so you help companies with such processes, because I would assume that as we said, so already the question what is invented is an issue. So then and this is an interactive activity to define that, and now we have this additional issue that we have a portfolio of inventions which maybe change over the time because of the fluidity of the software, and that the software has to be adapted to make really what it should do, and so on. And we have, in addition, now this regulatory process, which has also certain processes, certain recommendations, obligations, and that has to be managed. And this is, so you are the case manager for that, or how is your role in such a situation?
I think it will definitely it needs an interface with the patent attorney. Of course, there's a lot of internal arguments and structural steps you need to take, which may not be the attorney, because we are an external unit, of course. However, if you allow this and want this, we dive into this with you, and then of course have a specific look on this regulatory in your field, because they're not even each time the same. And then we can draft a process how to deal with that, on what people are responsible for what kind of point during this road. The good thing is with both patent applications and these regulatories is that there are certain deadlines or points that are crucial, like quality gates, you could say. And with this, you can really very well define a process which has these the steps that need to be taken before you cross the border. And by that, you have some quality management, of course, because you, on the one side, you decide on what kind of patent applications you want to have. You still need to know when you need to file it. On the other hand, from the regulatory side, you know when something gets published. And by that, you really come up, this concludes in, it really gives you a narrow view on in the future which step has to happen. And this, of course, takes some resources, of course, not only money-wise, but also from the company, that you need a division or at least one head of who's responsible for that and gets in exchange with the attorney. And of course, this is something not only done once, as you said correctly, this happens over the time. So anytime there is a red flag or a new quality gate or a new invention, this needs to be done. And this is also the reason why we always advise, make this process management, IP process management, and don't just rely on emails, which some people tend to do, some smaller companies, that you just receive from the attorney some email, say, okay, until this deadline, we need this instruction. Thank you. If you have this with one patent application, that might work, but if you have, of course, a complete patent portfolio, patent families over several different jurisdictions and authorities, like, I mean, this gets very easily complicated. You need to have a well-defined process for that, and thereby this is what we also do with our clients, which is very important.
Yeah, and so what I learned is that you have really a vision of a potential portfolio for your client, which you would like to realize. And that means, and then over the time, you try to organize to help that this portfolio becomes reality, so to speak. I mean, that is really something which I mean, that has a huge value. And I'm absolutely convinced that many companies don't know that. So they, as you said, they just interact on single decisions. So, but with isolated single decisions, you can never ever, maybe by luck, but in such complex situations, this is nearly impossible that you get a meaningful portfolio out of that. So you need really somebody who has that in mind, that vision, and is able to conduct then at the end accordingly that this will happen. One question which is also interesting in that case is that I mean, we all observe this huge development on software devices, obviously, but in addition we have also a further development in the field of patenting software. So what can be patented, what not. So this is not a black and white area, and it is not this is absolutely clear and this not. So it's really a step-by-step approach, and every decision or opposition or enlarged board of appeal decision, we know a little bit more. And so also the office has no black and white position here. So how do you deal with this, so to speak, moving target also of the framework of your work?
So the first thing is we always have a look at the current decision making. As you said before, what is there in the regulations, what are the current decisions on certain specific fields. If we find something there, to give a first indication whether this kind of invention has a good chance for patentability or not. But even though if you say this has a lower chance, we never say zero actually, because I don't see zero chances, because there's a lot of examples say this is definitely a technical solution there for a real problem. But you can target this by seeing that you have a certain shift in the decisions, because law is always a bit late with their decisions. They always see those cases that get denied, and then of course we have the boards of appeal deciding on top of that. So we are always a bit late, but you see that there's a shifting towards more, they at least are confronted with the digitalization. And if you think about that, it gets more friendly, probably. You should at least have a broad drafted patent applications with the specific use cases as a basis, for example. And then you can take a longer road, which means, of course, you can go for national one, then an international application, and later on go to the national regional phases. And by taking this time, of course, you also have some development in the decision making, and probably something that has today a low chance of being granted may have in 5 years a high chance. And specifically in the medical field, 5 years is not a long time, because these regulatories, they take probably longer than 5 years. So that your time to market is long enough that you can at least stretch the time when final decisions must be made. But of course, for the present now, it needs someone who is aware of the current decision making, what is the current shift. So you need that has some expertise, put that in, and then also see where this goes. So this is why I always say there's no zero chance. There may be a low chance, but I see definitely here the application would probably meet these requirements in the future. And also see it from another view. It's not only getting a patent, but as long as the patent application runs, this is still a defensive layer that you might have as an asset to your competitors. It's not always, people are always concerned, like, I need to get a patent. true, of course, it's a valuable asset, not arguing with that, but still having something that is to be discussed with the patent office and might be granted later while the chances now are low. This is also something competitors are scared of. So this still gives you some benefits on the market. So it's not like this black and white also decision if it's patentable or not now. There's also more to this question, if you should go for a patent or not.
Okay, I learned that it is even more complex. Yeah, not just from the invention itself, from the regulatory aspect, from the question of the market for this innovation. So also the framework itself is changing, and also this is a degree of freedom with which you can play and work with to at the end meet the objectives of your client. So Roland, thank you very much. I understand a little bit better. So typically physicists like complex situations, so that is what they are trained, and now we see here that you navigate through these very complex waters. We could talk for hours on that topic. It's really fascinating. So thank you very much for taking the time. And I'm looking forward to have another chance to talk with you about that. So enjoy, and thank you very much to the audience. Bye-bye till the next time.
Bye-bye. Thank you, Alexander. See you all.